we have some dignitaries in the building, so we may have some things that we'll have to consider. This is the Wednesday, May 22nd, 2019 formal hearing of the Utah Board of Oil, Gas, and Mining. We have a short agenda. We welcome those that are here. I think what we'll do is we'll go to the agenda item number 2, which is docket number 2019-014, cause number C/007/0045, in the matter of the Wellington Dry Coal Cleaning Facility. This matter has been continued to the board hearing on June 26th, and it may be continued to even a further month, but at this time I think we have it being continued until June 26th. Mr. Kissinger.
I think a continuation until June 26 is prudent currently, and we would support a motion for continuance.
Okay, so board members, that matter will be continued. We're now back on agenda item number 1, docket number 2017-013, cause number RONG-2017-01, in the matter of informal rulemaking associated with the 2017 and 2018 legislative amendments concerning forced pooling and the need to initiate rulemaking on other emerging issues and matters, including but not limited to rulemaking on operatorship designation. For the record, I'd like to just explain where we are on this docket. The proposed rules were revised after the April public meeting, where the board voted unanimously to send the proposed rules as revised to the Division of Oil, Gas, and Mining for formal rulemaking. That's formal rulemaking, subject to final review. Upon review, several of the members of the Board of Oil, Gas, and Mining expressed concerns with aspects and/or consequences of the proposed rules. Because this is rulemaking, any discussion involving a quorum and that would amount to any decision, this discussion is required to comply with the Utah Open and Public Meeting Act. Because this has been a docketed matter, if there are substantive revisions or remaining concerns, the board has structured discussions as to how to frame the remaining issues at today's hearing. A revised notice was issued last Friday, which was within the 24 hours required by the Utah Open and Public Meetings Act, just to make sure that this board deliberations are compliant with what is required in Utah. Because the board determines there are substantive revisions and/or materials concerning issues remaining, the board has elected to vet additional concerns not only in today's hearing, but the board will vote at the end whether to continue on the formal path or to step back and continue the informal rulemaking and then bring it back in June for an additional public hearing on the informal process. So if after these continued deliberation in today's public hearing reveals that there are no remaining substantive issues or concerns, the board could vote to send the revised rules back for formal rulemaking. Of course, once formal rulemaking again begins, public comment will also be received an additional time according to the time frames and manners prescribed by the Utah Open and Public Meeting, or the Utah Rulemaking Act. So having kind of laid out the formal language for the process, we'd like to go to Gordon Moon to discuss some of the concerns that you have and others that you've heard about.
I'd love to hear from Susan first, but she probably wants to hear from me first. Yeah, so from personal experience and from visiting with...
You're not on.
So just from my personal feeling as I've read all of the feedback that we've received on this rule and then visiting with a lot of people over this last month, I feel strongly that we should pull this back into informal rulemaking and take further input. I do want to appreciate all the work that's gone into the rule in its current form. There's been significant time by the division, the UPA, and our board, but there's further work that needs done on this. And I also wanted to say, I recognize the importance of the large operators in Utah. They put the most money up at risk. They drill most of the wells, and I firmly believe that we should streamline the process as much as we can to make the process simple and clear, so that we're not in the way. We provide some sideboards, but we're not in the way of them moving forward and drilling wells. But there are small owners that lease mineral interests that do play an important role in oil and gas development, in encouraging the process along, at times drilling wells themselves, but participating in wells. And for the most part, that's a free market process that's worked out between them, and usually for the positive. I would agree that there are times that small operators do play the system, and large operators, there's frustrations there, but I think the same thing happens the other direction, where large operators use their leverage to get agreements out of small operators that aren't felt as fair. But for the most part, I believe that's private negotiations, and working through that is the best way. Now, with all that said, there were needed rule changes, and we're in the process of working on those rules. And I just feel like we need more input from the smaller operator side to really understand how they will be impacted, and how this rule can be balanced and fair, so that we have greater recovery of oil and gas, but also fully protect the correlative rights of all owners in the wells. So that's why I have encouraged and am in favor of pulling this back into informal rulemaking, taking input, and then discussing it again, having a hearing at the next board meeting. So,
Are there any specific items or a list of things that you could discuss that we should focus on from your perspective?
yeah, and I'd like them to speak for themselves, but just one example is, to me, to have a small operator have to front 100% of their interest in the well before they can even raise a question about a concern on a joint operating agreement, to me feels punitive. So that's one example, and
Any others that specifically jump out at you?
In the subsequent well rules, it talks about how an operator, only an operator can request for subsequent pullings apply, subsequent force pullings, the existing force pulling apply to subsequent wells. I feel that should be owner rather than the operator, because it may be another owner that is proposing the well.
Oh, I thought we changed that to our owner.
Nope, it stayed operator. So
Anyone else want to comment?
I want to agree with Gordon's comments. I feel like we have not listened closely enough to some of the people that were here last month that objected to some of the rulemaking. In particular, Mr. Gunnell, I thought, had some very good comments. He submitted a comment letter, which was only Monday, but he submitted 4 examples of joint operating agreements that were punitive to owners and small operators that I felt brought up some really good points. And we have, the current rule makes it very difficult for smaller owners and operators to meet the standard to object. One of them is paying 100% of their AFE costs, and the other one is hiring a lawyer becomes expensive, especially if they're a smaller company, to object to some of these JOAs, and some of these JOAs are punitive. And if you look at those 4 examples that Mr. Gunnell gave, particularly one that made small operators responsible for getting rid of the gas on their property, we need to take that into closer consideration. One of the other rules that got published that was not in the rule as it was published for the April meeting was in R 649-2-9B. The risk compensation award in the JOA reached through arm's length negotiation between parties in the rule was added by Mr. Gill last month, and I objected to it last month and said that I would not vote for any rule that has that in it. Those are exactly the wrong parties to determine what the risk compensation award is. Essentially, we'd have every single risk compensation award be set at 400% by the operator and by those who have already paid into the well, which amounts to a taking in my view. And that needs to be struck. That is only one of the examples that I would give. But I agree with Gordon that having to pay 100% of the AFE up front to even object is a very high bar, and it should be changed.
Okay, any other comments? So, I think we're in a motion would be in order. Maybe I could suggest that. What I'm hearing you say is that we will pull this back from the formal process, return it to informal consideration. But before we make that a motion, I think it might be worthwhile if there's someone from the audience that would like to talk to us about the process of how we got to where we are today. You'll come forward, please. Identify yourself for the record and who you represent.
Thank you, Mr. Chair, for the
A
opportunity.
little closer to the mic. Pull the mic closer to you, please.
Does that work now?
Oh, that's a lot better.
Yeah. Thank you, Mr. Chair, for the opportunity and for the board. Obviously, I have not been present to
Please,
give
please tell, for the record, tell us who you are.
Thanks. Ricky Ranko Browning, President of the Utah Petroleum Association. I thank the opportunity to be able to speak with you today. Obviously, I haven't had a full view of the Utah Petroleum Association and our member companies' engagement through this process and the issues that have been raised from the very beginning. But I do understand that our members, represented predominantly by Mr. Fred McDonald in front of you all over the course of several years, I think more than 2 years through informal rulemaking discussions, have been negotiating in good faith on the key concepts that were brought before you at the last meeting. We certainly want to ensure that this is a rule that works for all parties. Our membership, just to be clear, does include larger operators in the state, but also smaller operators as well. We have a range of different size companies. And the negotiations that have gone forward over the course of several years have included a number of compromises from our members to get to the draft that you are in the process of reviewing. I know that one of the key issues for our members has indeed been the upfront payment. There is a concern about the opportunity for a smaller operator to be able to game the system, to be able to draw out timelines. And that's one of the reasons that we felt very strongly about the need for that upfront payment and skin in the game. We are not opposed to continuing to discuss other opportunities to evaluate that, but unfortunately today I obviously can't take a position on behalf of my members, as I've just heard the detailed concerns that have been raised. So I'm happy to go back and work with my members on a position. And I just want to very respectfully say that as we have been in good faith negotiations over those several years, and that is one of the principal concerns from our combined association members' points of view, that I do have some concerns as to what some of those other compromise positions would look like if that tenant were to change. So we're happy to discuss what we can do to make this a rule that works better for everyone. But do recognize that that's been a pretty predominant underlying issue in our other compromises already made.
Thank you very much.
Have you had some feedback from any of your small operators that have engaged in looking at this rule?
So UPA operates on a committee basis. We have an upstream committee that is open to all of our upstream operators. To the best of my knowledge, there hasn't been any significant dissenting view on that issue. But again, I've only been with the association since January, but to the best of my knowledge, no.
Just to comment on that, I think a lot of this, I don't fault anyone for not doing their best to get the word out. UPA, division, but there were a lot of small operators that just had no idea that this existed until the last board hearing. And, you know, one of them got here, 3 or 4 comment letters, but since then there's been more that have become aware of it. So, you know, on behalf of myself and small operators, you know, we are engaging in this later than we should have been, but didn't know is their defense, shouldn't be my defense, you know. I knew this was in the process, and we've seen drafts, you know, a couple drafts over the last few months. The early on things, you know, we weren't, but I could have been, but didn't. But we are kind of where we are now, and we want a good rule, and you know, just a comment, general comment. You know that there are times when large operators can game small operators, just like you mentioned, small operators can game the large. How we remedy that, that's a case-by-case basis. I mean, there's leverage differences. A large operator has invested more, they have more leverage. They own more of the unit, they've got the money to drill the well. So they ought to have some leverage, and they ought to be able to make a return on their oil gas gathering and compression, or their water hauling, or their disposal. They ought to be able to have some profit on that. And how much is too much? You know, you can't extract that all just from the small operators. So you know, I would hope to have a rule that tries to protect both sides. But I think in general the time periods. I mean, I think something that did need corrected is we do have specific times when responses have to happen. You know, and those are the important parts of the rule, where there's specific timelines and it's clear what needs to happen in order to consent to a well. Those are important things, but anything that puts one at more of a disadvantage, those are the parts that I'm hearing concerns about. So.
I just want to say I don't think anyone's doubting the good faith efforts that went into the whole exercise thus far. And I'm not an expert in these matters at all, but if we can end up with a better rule with a month's delay and getting more buy-in, it's gonna make for a stronger rule. And I think also anything we can do to avoid the law of unforeseen consequences kicking in, I'm supportive of that.
So, thank you very much. Anyone else
Thank you.
want to address us on the process? Because we're going to take more, we're going to go back to receiving more information. Okay, so that you're making an informed decision, the motion would be to send this back to informal process, and then bring it back for a discussion and vote on whether it should go forward into the formal process at the June hearing. Everybody understand that? Okay, any comments on that motion?
So are we going to kind of give direction to everyone on what is expected as far as comments, and then what's going to happen?
Yes, at the beginning, we said that in terms of the comments, there are comments and those comments that actually come in with suggested language. That if you're going to comment, you pretty well need to let us know exactly what it is you complain about and how you would fix it. And that's the proposal that is before us.
And then timing-wise, when do those need to be in? Because, we have, once again, a lot of times, because they just didn't know about it till recently, but it'd be nice to see their comments.
Yeah, I'm going to leave that to the division, because they run the informal. And then again, remember, even if we get those, make the changes, adopt them, discuss them, and then go forward with the formal, we still have one more chance at getting this, additional amendments in the formal process. So I don't know that there's a timeline, but I think it's now, and it's up to people to respond as best they feel that they can.
And would there be, and maybe the division's got this figured out based on, but would there be some informal meetings and discussions, or would it just be us taking comments and then having a
The comments will go to the division.
Okay.
Okay, the comments will go to the division. Natasha is given the task of accumulating those. We are asking for at least a meeting or something where people can come in the informal process and give their input to the division, so that they have some understanding. So, because we need a division recommendation. But I think you need to go in this with your eyes open. And what you have is a compromise. It was called a consensus, but it was a compromise. What we're doing today blows that up. And that compromise was from the industry and the division. It was from large operators and small operators. And so what was on the table, we just lost. And so this is a big step. And you've asked people to come together and try and work out compromises. They did it. And we're going to blow that up today. Because I'm going to vote for the motion. I think that'll be probably for it. But I think you need to understand that this is not going to be just some fine tuning. You have made a material, we are going to make a material dent in the progress of a lot of people weighing the pros for the large, the small, regulators and things like that. So please be aware that this may become a lot more problematic than an agreed upon compromise bill, consensus bill, whatever you want to call it. With that, Mr. Baza and then Mr. Allred.
Thank you, Mr. Chairman. And Mr. Moon, in trying to answer your question, I will tell you that after last month's board meeting, the division was prepared to move ahead with the formal process. We had some deadlines established of when to file with the Division of Administrative Rules to make that happen. With this hearing today, the division has really even had a chance to digest the 2 comment letters that have been received in the last few days. So I think we need to look at those. We need to compile what constructive changes could be made to the rule. And then, as Mr. Gill has indicated, we would have to come back and provide our recommendation on what should change, if anything. But I think we need a chance to look at that. If more meetings are necessary, we would rely on people to come and ask us if those meetings are necessary. But at this point, we were finished with the informal part, ready to move it to a formal rulemaking. So now this extends that a little further, and we certainly want to give everybody the chance to provide their feedback. But as I said, we haven't even digested the 2 comment letters that have come in the last few days.
And I think it'd be helpful to us, John, if you wouldn't mind my commenting, that on the joint operating agreements that have been proposed as being egregious or having issues that are unfair in them, I don't believe I've ever seen one of those in a hearing that we were asked to approve. But if that is the case, I would like to know the docket number of where those JOAs occurred, and we were asked to give our approval of them. I think they're outliers. I don't think they're common. They may have been a problem, but I don't remember seeing one like that.
Again, we'll have to do a little bit of research and
Yes, if you could
compiling
tell
of
us
the
that. Okay.
comments.
Mr. Alder, were you, Mr. Baza, were you done?
Yes.
Thank you, Mr. Alder.
It's okay if I have anything to say. So I would just like to comment on the fact that this is, I think, a process that is in your hands, as I said last month, and to the extent that there was a compromise, I think that took place out of the sight of the division as well as out of sight of the board. Mr. McDonald is probably the person who best understands the give and take that took place in the proposals that the Utah Petroleum Association put forward. The division appreciated the fact that the Utah Petroleum Association's response to the division's initial comments conceded some of the division's concerns, which we thought were helpful to small operators. But it certainly was not as if the division was representing or had actually heard very much from small operators. So I think to the extent that maybe the word got out late, or maybe that's just a complex sort of area that people didn't want to read about, or maybe I didn't make it clear enough in the presentations that we sent out. I think it's apparent now that there are some concerns, and it certainly, as Mr. Borden said, it's better to hear those concerns. It may just be fine-tuning, but we'll have a better rule. We'll at least have better buy-in. We'll have people who say, I understand the arguments on both sides. So to the extent that the division can cooperate and help, we will, but and I appreciate that the division may make a recommendation, but it's really up to the various, the division doesn't represent large owners or small owners or large operators or small operators. We're just trying to help digest the impact of this rule on the industry, and to the extent that we can do that, we certainly will.
Thank you very much. We're back to the board now. Does someone want to confirm that we have a motion before us to send this back to informal rulemaking?
Yeah, I think we're getting close. I just want to have clear to those in the audience and those watching what they need to do if they have with their concerns. We had a couple comment letters over the last day or two, and we've had conversations, but do they just send those in just like they have, and then?
Yeah,
Because, you know, I like the idea of the discussion and the compromise, and if there's gonna be, you know, the UPA to be able to voice their, because what I heard, you know, I understand there's been some compromise, but kind of it was division's attorney working it out with the UPA. I'd just like to understand what we could come up with as far as there being that happen. If it's needed. I mean, what do we?
Okay.
Yeah. Are we just asking for letters, or are we?
Well, at the June hearing, we'll take testimony.
Okay.
So you can either write it or come to that hearing and express your concerns.
Is that okay with the
Yeah, I mean, I
UPA,
think-
that there's not gonna be a sit down at a table discussion?
I
Just a
think-
hearing in front of us next month.
My personal opinion is that we're past that if we get comments before, in time to present a response to those comments, I'm sure Mr. McDonald would want to
Okay.
do that, and I certainly would want to do that. But as far as actually working out the compromise, I don't think it should happen outside of the board. I think the board should be a party to whatever compromise gets worked out.
Yeah, because they just work, because the way you framed it, it's all been blown up, and I
Yeah.
didn't know that, I mean, we have a set of rules and some adjustments gonna be proposed.
Yeah, and
So what you're saying is you don't see the need or envision a sit down, talk it out again?
I think I'd let the Petroleum Association invite that or not. However they want to do it. I think they're going to have some work within the small operators and large operators inside their organization.
Yes, Ricky Ranko Browning again for the record. You know, it's challenging for me to say how we're going to respond without knowing what changes you're going to want to see. If we're talking about wholesale changes, such as removing the requirement to have payment up front, we probably would want the opportunity to have some further discussion around what other unintended consequences there are and other issues that touches that we may want to see changes on. The challenge that we have is, you know, comment letters coming in, such as has happened today, just with less than 24-hour notice, for us as an association with multiple companies to come together on a position to an issue raised 24 hours ago, it's not feasible. So in this process, if there are going to be new issues raised, and UPA is going to have the time to adequately respond from a consensus position, a 24-hour time turnaround is not going to be feasible.
Okay, I think that what you're asking,
Yeah.
let's give 2 weeks
Yeah, that's what I'm
For-
after.
let's
So
get-
if we're not gonna have any meetings outside of.
for
the board
additional
hearing-
comments, and then let people know that those comments that come with, that meet our request, that, okay, what is it you would put, what language would you put in it, or would you delete from the rule to meet that? So let's give a 2-week comment period, and that gives everyone a fair chance. Is that long enough period of time?
Well, 2-week comment period, but then you would want the opportunity to respond to that.
Yes, we would
And like-
take whatever you propose and go back to our members to come up with a consensus position.
And then, as I understand, you know, with our request, those comment letters that come in that just say, well, we're uncomfortable with the rule and don't tell us how, or don't tell us how they would fix it, will get less weight than ones that come in and say, you know, here's the problem, here's how we would fix it, and here's why. I think would be more valuable at this point in time. Does anyone want to comment on that idea? So we'll give it 2 weeks? Is
2
that
weeks, and then opportunities to respond is,
to the comments? With another 2 weeks to respond to the comments or at the
Well,
hearing?
that's, yeah, maybe 10 days, so we get the responses a few days before the meeting. Something like that.
Yeah,
Or 22nd, yeah, there's actually more than a month between now and the next hearing, so that would work.
But if we did 14 days and then another 10 days
To
for
respond?
responses, that way we can have them all.
We will endeavor to make sure
Not
that
like
that
we're gonna cut it off,
works.
But just so that it,
I think that's our guidelines, okay?
Why are we trying to meet the June meeting? What about July?
I think.
I'm okay with the June
Yeah,
meeting.
I-
I'm just
I
saying this
think
seems really
there's-
quick.
I think, the concerns have been brought up. I think it could be.
The concerns
they could be-
are pretty much limited to about 4 issues.
Yeah.
And we ought to be able to agree. But if
Okay.
at the June hearing, we still feel like there's outstanding questions, we'll go to July.
What
I
I
mean,
heard,
it's not-
what I heard the chairman say was we would vote in June to see if it stayed informal or went to formal.
Correct. So, let me rephrase the motion as I understand it. The motion is to continue, to move the rule, the proposed rule, under this docket to, back to informal, and then to schedule it for the June hearing for a discussion of the input. The input is, they're given 14 days from today to get their input in. And then, I don't know why we limit to 10 days. We could have another 14 days to respond.
Yeah, but
And
at
that
least
gives us about a week, a half a week to
Yes,
look
as
at
long as
all
we
of it.
have time to look at it.
I suggest 14 and 14.
Does that mean we'll have a new rule to look at the end of 28 days? Is that what you're saying? No.
Well, no,
No, just the input.
just the input, because that has to be at the hearing. But what we will have, hopefully, in the input is the suggested changes that we could look at. Okay, is there a second to that motion? Okay, everyone feel like you understand the motion? Okay, the motion before you is to continue this, or to send it back to informal, give 14 days for input as we've described it, to give 14 days for responses, and then also open the hearing in June to additional comments, discussions as the board deliberates it. So we'd ask that there be witnesses here to discuss those, both for and those making the comments and those responding to the comments. All in favor, say aye.
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 Any opposed? Let that show that that was unanimous. Thank you very much. Anyone have anything else that needs to come before the board today? Seeing none, then a motion to adjourn is in order.
So moved.
All in favor, say aye.
Aye.
That passed unanimously. We are adjourned and off the record.